Hi, thank you for joining me. We are probably against your will, but thank you for joining me anyways. We are here to discuss will interpretation, specifically mistakes and ambiguities. In your reading, it discusses patent and latent ambiguities. You do not need to know that distinction for my purposes. Let's start out with our primary rule of construction. It is the plain meaning rule, meaning we start with the language of the instrument itself, and if it is clear and unambiguous, the court has no choice but to use the plain meaning of the words. If there's no ambiguity, we don't look at testator's intent. We stick with the plain language of the instrument. The courts are very, very formalistic. Now, if we have a will validity question, so to establish the validity of an instrument, we do allow extrinsic evidence in, meaning we'll look at testamentary intent. Extrinsic evidence, as you know, is defined as anything outside of the four corners of the instrument. So when we talk about looking at testator's intent, that's extrinsic evidence. We will look at intent. We will look at extrinsic evidence to establish the validity of an instrument. Has the testator complied with testamentary formalities? But once validity is established, courts are much more restrictive about when they allow extrinsic evidence in. And the general rule is no ambiguity, no extrinsic evidence, although there are a lot of reasons why extrinsic evidence may be brought in. But I suppose the point here is once you have passed validity in an analysis, you need a legal reason to bring in extrinsic evidence, to be discussing extrinsic evidence, to use extrinsic evidence in your analysis. You need to give me some reason. Now, let's speak first about errors or mistakes, and then we will talk about ambiguities. Our general rule with mistakes is that a court won't fix them. Now, this is a harsh rule, and you may be laughing because we have examples throughout the class of times that we fix mistakes to carry out testator's intent. A court can get around an unnatural disposition that disowns a family member through doctrines such as capacity, fraud, undue influence. A court can undo mistakes in revocation through the doctrine of DRR. A court may remedy testator's mistaken disinheritance of a child by treating the child as a pretermitted heir and giving the child some statutory portion of the estate. Mistakes as to legal effect, so as to the effect a provision will have, the general rule is that a court's not supposed to correct those provisions, even when the decedent relied upon the advice of an attorney. Now, of course, a court can always treat legal significance of words as ambiguous and deal with it accordingly, usually by bringing in extrinsic evidence. And it's not uncommon, especially when the court is dealing with a layperson, that is how they address mistakes as to legal effect so that we don't have a harsh consequence. So you may see, for example, take the language, all of my personal property. That has been interpreted to mean all of the property that belongs to me personally, rather than all of my personal property and not my real property. And this may in fact be a better way to approach attorney mistake. rather than automatically going to the doctrine of malpractice, which is something I actually consider in one of my articles. You then have what we call the scrivener error. The scrivener error is sometimes, but not always, corrected by the court. So what is an example of a scrivener's error? Testator leaves 25% of the residuary to 3 beneficiaries. It's clear in that circumstance that the drafter was a lawyer who was bad at math. Should we fix that mistake? If it's obvious, you frequently see courts doing that. We have a doctrine called falsa non demonstrata. It is labeled in Barbary, or called in Barbary, falso demonstratio non nonset. So basically, can a court correct mistakes or ambiguities if the court can strike out words? The Latin meaning of falsa non demonstrata is that a false description does not vitiate, or a false description will not make this instrument inoperative. And there are some very interesting cases in the casebook on this. If you look at the PowerPoint, I have an example where testator owns a home at 170 Barclay Street, and in his will, he leaves the home to A, and he refers to it as the house at 710 Barclay Street. So the number 710 is a false description. It is not ambiguous. It is a mistake. We have 2 important rules. First, a court will generally not correct mistakes. And secondly, the court will not allow extrinsic evidence to be brought in or introduced without an ambiguity. So if we apply the doctrine of falsa non demonstrata in the next PowerPoint, our first step is to strike down the mistaken description so that the language of the will then reads, my home at blank Barclay Street. Now, either this will be a sufficient description, or we are then allowed to bring in extrinsic evidence to clarify ambiguity. Another example, testator devises $5,000 to his niece, Sally Mary Winters, when his niece's actual name is Sally Kate Winters. In that circumstance, we apply falsa non demonstrata. We strike down the middle name, so it would read Sally blank Winters, and we either probate it that way, or we bring in extrinsic evidence to clarify any ambiguity. Another example up on the PowerPoint, testator devises property to my cousin Henry. Testator has a cousin Henry and a cousin Cecil. Can Cecil introduce evidence to show that the testator intended him to take? And the answer is probably not. In that circumstance, the plain meaning rule survives, and the devise to my cousin Henry is not reasonably susceptible of meaning my cousin Cecil when there is a cousin Harry. And so one does not typically see falsa non demonstrata applied in that circumstance. So that was a mistake. Next, we'll talk about ambiguity. Extrinsic evidence is admissible to explain ambiguities. What does, or how do we define an ambiguity? Something that is reasonably susceptible to alternative identification or alternative meanings. Once we've established that there's an ambiguity, most relevant extrinsic evidence is allowed in to clarify the ambiguity. For example, extrinsic evidence with regard to the circumstances under which a will is made, or extrinsic evidence of conversations had by the testator. The court will not allow in extrinsic evidence if there is no ambiguity, meaning we're looking for something that is reasonably susceptible to alternative meanings. There's a very interesting case on this in Ray Estate of Russell. It's a California 1968 case. Now, we have personal usage exception. Personal usage exception, we allow extrinsic evidence in to clarify an ambiguity. We, with personal usage exception, allow extrinsic evidence to be brought in to show that testator habitually used words to indicate something that is not clear on the face of the word or not clear from the word's meaning. The testator is using a phrase differently than the commonly known meaning. At one place that I taught, there was a faculty member who referred to his significant other as cupcake. And it did not matter if he was introducing her to strangers, if he was discussing her in conversation, if he was speaking about her in passing or on the telephone. And he, of course, gave me permission to use this story. He insisted that in his will, he also names her only as Cupcake. Now, in that circumstance, we have testator using a word, here the term cupcake, in a way that is different from its commonly known meaning, and so applying personal usage exception. We could bring in extrinsic evidence to demonstrate that he always used the term to mean his significant other. An interesting example of ambiguity is found in your casebook. Testator is a resident of Northern California, left her estate to the University of Southern California, known as the UCLA. And for anyone who knows and understands the rivalry between USC and UCLA, this example is somewhat humorous. Now, there was disagreement between the lower and appellate court in this case. The lower court held that there was no ambiguity and interpreted the language to mean the university in Southern California known as UCLA. The appellate court reversed, held that there was an ambiguity and that extrinsic evidence could be brought in to clarify. What about when an attorney drafts an ambiguous will? Now, there's conflicting opinions about what to do when an attorney drafts an ambiguous will. Does the ambiguity rise to the level that a malpractice claim would be appropriate? Because it's difficult, if not impossible, to draft a document that is completely free of ambiguity in every situation. With that said, there are some cases, extreme cases, in which malpractice liability may be warranted. Let's look now at an example I have, an example that was tested in some form on a previous exam. Grandmother leaves $100,000 in her will to Mr. and Mrs. Michael Mancini. At the time of her will execution, her granddaughter is Mrs. Jane Mancini, and this is available on a PowerPoint. 1 year later, grandmother loses capacity. 2 years later, Jane divorces Michael. 3 years later, Michael remarries, and 4 years later, grandmother dies. So the issue, will Jane inherit, or will Michael and his new wife inherit? Stepping through mistake versus ambiguity, stepping first through mistake. Is this a mistake? Is it a scrivener's mistake? Did the attorney make a mistake in using the language Mr. and Mrs. Michael Mancini in today's world where divorce is relatively common? The general rule is that the mistake is not going to be corrected by a court. if it is in fact a scrivener's error. What about using falsa non demonstrata? A mistaken description will not vitiate testator's intent. So we would cross out the words Mr., the ampersand, and the word Michael. This leaves blank blank Mrs. blank Mancini. And possibly then we could introduce extrinsic evidence to clarify any ambiguities as to the identity of Jane. I do agree that this hypothetical strains the doctrine of falsa non demonstrata. Is there an ambiguity here? If you can argue that there is an ambiguity, you could introduce extrinsic evidence to prove up Jane's identity. And finally, is there a possible action against the attorney for what ended up being ambiguous drafting? And that concludes our discussion of mistaken ambiguity.